here on KTN News. But something else that we're covering very intricately is, of course, the NASA petition at the Supreme Court. And today, President Uhuru Kenyatta's team is going to be taking the stand this morning at the Supreme Court to make the case before the Supreme Court judges after opposition leader Raila Odinga and the IEBC made their case yesterday. Now, while Raila's team stuck to the submissions on violation of the poll laws, IEBC and its chairman insisted that the claims had not been backed by evidence. The Attorney General and the Law Society of Kenya will also make submissions after they were enjoined as amicus before Raila's team makes their final response. The court will also receive the report on the audit of the election materials and the system. So we just want to get the views of my guests here in studio. It's going to be an interesting and a long discussion really about just where we are at so far, looking at the evidence that was put across yesterday by the NASA team and what really to expect today. Let me introduce my guests this morning. I'll start from my extreme right, and of course Murigi Kamande is not a new face here on Kivumbi 2017. I hope you're doing well. Thank you very much for joining us.
Thank you.
We also have Duncan Okach, who is also a lawyer, and he's also been with us here on Kivumbi 2017, just trying to help us really analyze and understand what's happening in the corridors of justice. All right, gentlemen, I just want us to start from the conduct of the case so far. I mean, it has been about five days, and you know, a lot has happened. But I just want to hear your general thoughts and assessment about just how the court has been carrying itself out and the conduct. I'll start with you, Duncan.
Betty, I think from the word go, once the judges walked into the courtroom, you could easily notice that it's not business as usual.
Right.
You just looked at their attire. They didn't have the dull attire that the
Yes.
former CJ introduced, and they actually looked elegant. And if there's a reason behind the red and black attire. It's actually symbiotic, and it goes to the historical aspects and ideological perspective and meaning of that particular court. So it actually sent a message that we are different. But from the word go, you'd notice that the court also tried to invoke a semblance of respect among themselves and the bench, and you notice that they actually ensured that everyone it was a cordial affair.
Right,
it was a civil affair.
Right.
They actually also have indicated that they were going to be very strict on the time frame, because they also wanted, and it seems like they want to do a very good job, so that they want enough time for them to do their judgments.
Right.
But more importantly, you notice that even as they are allocating time, they are very keen in terms of who they're introducing,
Right.
the time they are allocating, and they are keeping that. So an issue of orderliness and a semblance of change has actually swept across those corridors of justice.
All right. Murigi, do you feel the same that 11 days into this petition, there's something different from 2013, just looking generally at the environment and just how the judges really have been carrying themselves out?
Yeah, exactly. And if you look at, you'll tell there's a difference between the way that the court conducted itself in 2013 and the way it did right now. You remember during the appointment of the Chief Justice, the Deputy Chief Justice, and the appointment of Lenaola as a judge of the court of the Supreme Court, we did observe that what we have right now, they're practitioners, they are judges who've been in practice, who have been judges previously. And so the question now that arises is, you can say there's sobriety, there's that they are engaging the parties. They are focused. They know exactly what they want. And then at the same time, you do not want to see. You remember last time there was this feeling that the Supreme Court was imposing itself on the parties. But you could tell right now, even the way the Chief Justice is conducting himself, he's ensured that there's a level of sobriety in that court. He cracks jokes with people, so he does not want to be seen as if there is these strict. I know they are strict in terms of the law, but in terms of the way the court is supposed to be conducted, I actually should give them 100%. They've conducted themselves really well.
Wow, that's a high rating.
Yes.
Just also looking at the comparisons between this petition and 2013, quite a number of people are saying that you know, they're not really held at the throat by the technicalities. They've been able to admit submit, documents or, annexures even after the timelines, had already passed. What do you make of this cordial environment that the court this time has?
Betty, the analysis of the proceedings in the 2013 case and the criticisms and analysis of the ruling thereafter may have actually informed this court in terms of points where they could learn and points where they could improve. So they have that benefit. You must remember that 2013, it was a semblance of judges who had not been together for quite some time. Yes. And more importantly, it was the first petition under our constitution. And if you look at it, the timelines were there. There's obviously room for some confusion because they don't have any other learning experience. This was the first time that apex court was sitting. So there are issues that may not have been done to the expectation of the common mwananchi. And I think this court has had that particular benefit of looking at that, at whatever this particular court didn't do well, so that they have perfected it, and that's why my learned colleague will actually give them 100%. 100%. But more importantly, there are, even as I say that, there are also some aspects which, as a lawyer or as a judge, some aspects should actually remain true, regardless of whether you are appointed today or whether you've been in that bench for 100 days. Okay. Because once the Constitution is clear in Article 159(2)(d) that justice will be dispensed without undue regard to technicality, and it means that you'll actually give credence and precedence to substantive justice as opposed to procedural or technical justice. And this was actually to cure a lot of the ills that people had suffered before, just because the substance of your case is defeated just because of a very small technical aspect. Yes, yes. And if you look at that, the Supreme Court then actually threw out some 900-page affidavit because of the issues of technicality, when we have even inculcated in our civil procedure rules something lawyers call the oxygen principle. It breathes life into that particular rule, such that we are not bound by technicality. But if you look at this particular sitting, you'll actually notice from the word go, the Justice Maraga actually indicated and even tried to find consensus from amongst the councils that these issues that each side is bringing, and you actually saw they were so keen on relying on technicality to such a point that they were actually putting that particular provision again to the test. Yes. Because it was upon the judges to say, do we again uphold what our predecessors did, or do we actually give credence to the Constitution itself? And they actually decided that it is better to give credence to this particular provisions of the Constitution and try to get them to concede. But when they didn't, their rulings, the rulings that they gave the day before yesterday and yesterday morning, actually you look at it and you actually see that they've departed from the jurisprudence that was laid down by the Supreme Court in 2013, and it's a clear departure from that. And people have praised it. People have, and both sides have benefited out of it.
All right, Murigi, your take also on the same, just comparing, both 2013 and this time round, but also just putting special focus in your answer in regards to the rulings that we've seen so far from, the day before yesterday and yesterday, the dismissing of some applications of a few people and the admitting of other people to be enjoined as amicus. So what's your take on all that?
What I would say, it was a really wise move, the rulings that they gave, for example, in terms of, there are certain people who are literally busybodies there, that their joinder would not have aided the court, and that's the reason why it was justified in dismissing the applications for joinder. But if you look at other interested parties, there is no, the court agreed that as long as, for example, you are a presidential candidate, you have a stake in the election. So that was the basis on which both the Kurau Court and Professor Wainaina were joined. You also look at the amicus, for example. The court, the court looked at the broader I will call it, the broader focus, which was in terms of what will you assist the court. And that's the reason why they were specific in actually admitting the Attorney General. He was to restrict himself to a certain line of argument, and there are certain issues that he was supposed to focus on. Right. And also by admitting the Law Society of Kenya, the LSK, they were limited to only interpretation of Section 83 of the Elections Act. So
Yes.
that was a wise move.
Right.
And then also in terms of the rulings to expunge documents, the court itself, the reasoning itself is what you would tell that this actually is a court that wants to dispense justice on the basis of substance, not technicalities.
Okay.
So there was no reason why, for example, you would dismiss because applications have been filed, for example, a few hours late, or they have not been served.
Right.
Because in essence, what they would have done, they would have thrown out certain parties' cases.
Yes,
and
yes.
therefore, what I really think the court wants to do is to look at the substance and to evaluate these elections so that everybody out there is satisfied that we have an apex court that works and that knows what it is really doing.